Hello, this is Sean Roche. I've got noon on my clock, so we'll go ahead and get started. I'm sure there's a few folks that'll be continuing to join here. I'm Gaffam, Georgia Association of Floodplain Management NAI Committee Chair, and also serve as the ASFPM NAI Committee Education and Outreach Liaison. Today's session is the 11th in a series of webinars, Lunch and Learn webinars that we've sponsored. With NAI-related topics. We've obtained permission from ASFPM to award one continuing education credit for today's presentation. To capture those in attendance, if anyone would please send a chat with your name and whether or not you're a CFM, we'll include you in the list of attendees that we submit to ASFPM requesting credit for today's presentation. Before we get started, I'd like to go over some housekeeping rules. Please put your phones on mute if you're not speaking. We'll have an opportunity to ask questions at the end, but in consideration for our speaker and those listening, please put your phones on mute so we don't hear any background noise. And also, please don't put the call on hold, because as you've all heard, we'll hear everyone's mute back, and that, of course, will interfere with our presentation. So if you need to drop off, please feel free to drop off and then sign back in when you're free. Also, I mentioned we'll have time at the end for questions. I'd like to introduce our speaker, Samantha Block, now. On that, Sam, I'm going to go ahead and assign the presenter so you can start getting your presentation up. As is your bio. Sam is a Policy and Partnership Program Manager for the Association of State Floodplain Managers, serves roles for the Association and ASFPM Foundation to provide leadership in national flood policy initiatives, foster partnerships with allied agencies, organizations, and academia, and serve our members and mission. Sam has more than 20 years of experience in land use law, mitigation, and environmental policy, working with stakeholders, regulators, and utilities, as supervisor of floodplain programs for the Lower Colorado River Authority, the director of the Flower Mound, environmental with the North Central Texas Council of Governments, and the disaster recovery teams in Guatemala, Honduras, Nicaragua, following Hurricane Mitch. All of these programs, cooperating technical partners, stay involved in the federal flood studies and NFIP mapping activities in rapidly urbanizing areas. Prior to ASFPM, Sam led numerous initiatives to promote a safer development standards and flood risk, including co-authoring the first law review article to tackle NAI legal issues, creating misery, land use and protection of property rights before the next big flood. In 2010, Sam received the Army Commander's Award for Public Service in recognition of her service as a member of the National Committee of Safety, to address challenges in an integrated risk management approach. With that, I'm going to hand it over to Sam. Thank you.
Thank you much for that introduction, Sean. And I want to thank everyone today for making time in busy schedule to go through the legal aspects of no adverse impact as applies to floodplain flood risk management. We're just going to jump right in. And like any good lawyer, I begin things with a disclaimer. This presentation is neither intended to be nor should it be taken as legal advice. For legal advice, consult an attorney licensed to practice in your jurisdiction with expertise in the subject matter. Of course, statements of fact and opinions expressed in this presentation are those of me individually, and not the position or opinion of the Association of State Floodplain Managers or GAFM or the ASFPM Foundation. Having dispensed with that friendly disclaimer, let's dive right in. Everyone on this call is familiar with ASFPM and our mission to reduce the loss of life and property in flood disasters and to protect natural and beneficial functions of plains. Chair, we are up to more than 15,000 members across the country, 35 chapters, ASF is growing and carries a strong voice on these issues, both in the Congress, with the administration, and in the court. The briefing will be going over some basic background and spend most of our time talking about the Constitution, the Fifth Amendment, and takings as it relates to reducing flood losses, and then wrap up with ideas around no adverse impact and reducing the potential legal liabilities for communities, for your employers. I may be one of the few lawyers in the country that you're going to talk to about these issues whose main goal is to actually keep folks out of court. Some of this background, we know that policies at all levels of government can actually contribute to risk. And with the federal policies, we have the NFIP and the so-called 100-year standard. Historically, we've seen a real emphasis on structural approaches, like levees, flood walls, dikes, and not as much of an emphasis on structural approaches that can reduce both risk and potential legal liability. We find ourselves still in a disaster relief environment where we are dealing with flood disasters more after the fact. Even so, we are seeing states and communities leading the way in addressing flood risk through the adoption of higher challenges or higher standards. And one of the things I'll emphasize repeatedly in this briefing that states and communities are on very good legal footing in adopting standards and approaches that exceed those federal minimum standards. And land use is controlled with a short-term view that could potentially increase liability. Historically, and communities have perceived particularly catastrophic flooding to be a federal problem, and some of those decisions have resulted in externalization of the costs and consequences to the nation overall. We have a public that is largely either unaware of their risk, or when they're made aware of it, they may be unwilling to accept it. That's particularly true in the case of residual risk. It's a risk that is residual even once one has adopted standards, pre-development in certain risky areas, or built a levee. Times when folks are informed that, sometimes for the first time, that they find themselves at risk, the concern is not, at flood risk and didn't know it. The concern is about now having to obtain flood insurance. So we are seeing more states and local governments getting active and adopting higher standards than those federal minimums, and on very good legal footing in doing so. So only if you rely solely on federal minimum standards, it can be new development and even redevelopment post-disaster in hazardous areas. Those minimum standards do not take into account adverse impacts to adjacent and downstream properties, and don't also value properly the natural and free protective purposes and functions that naturally functioning coastal ecosystems and floodplains can provide. What emphasizes that the impacts can actually result in potential liabilities in the form of successful common law or constitutional takings lawsuits brought against either a developer or a community, despite the fact that a community has adopted and is complying with the minimum federal standards. In general, if your community is going to development that results in an adverse impact, you can be liable if you have adopted and met the federal minimum standards. By way of background, you're good footing, obviously, in managing land use development. Go all the way back to the 20s. The basic foundation for planning and zoning in the United States was laid out by these two standard state enabling acts in the 1920s. The Standard State Zoning Enabling Act that was by an advisory committee on zoning appointed by, at the time, Secretary of Commerce and later President Herbert Hoover. It's gone through several revisions and a revised edition in 1926 that had 9 sections that include a grant of power or authority, provision that the legislative body could divide local government territories into districts, a statement of purpose of those zoning regulations, and procedures for establishing and amending those zoning regulations. 1930, that Standard State Zoning Enabling Act has been adopted by 35 states. Then we have the Standard City Planning Enabling Act of 1927 that covered everything from the organization and authority of a planning commission, the authority to prepare and adopt a master plan, dealing with physical development in the territory, the provision for adoption of master transportation planning in the form of a street plan by the governing body, provisions for public improvement, and control of private subdivision land. The Supreme Court weighed in the case of Youth v. Ambler, 1926, when a comprehensive zone ordinance was challenged. This court concluded that regulation of land use, including excluding certain uses, is when a state's police power. These police powers are around protecting public safety, health, and welfare. This means that it's core in the Fifth Amendment to the U.S. Constitution that states that no person shall be deprived of life, liberty, or property without due process of law. That due process provision finds itself as the subject of litigation and a well-developed line of constitutional jurisprudence. The judge also states that nor shall private property be taken for public use without just compensation. And we'll get into exactly what is meant by a taking, that taken, what is meant by public use. What does the court mean by just compensation? As an overview, there are essentially three and really four, but three types of takings that we'll be talking about. The first being physical takings. This is actual invasion or occupation of private property. Generally, physical occupations of property are per se takings. This is gets to one of the fundamental tenets of private property rights in the United States, which is nearly unique in the United States. We have a very special relationship to the land. Being, we talk about these rights as fixed and bundle. When a primary fixed and bundle of private property rights is to exclude others. So this is where physical takings can come into play. And when a court is looking at a situation of physical taking, it's a taking per se. Regulatory takings, and there's again an advanced line of jurisprudence around this. And this occurs in a government regulation like National Flood Insurance Program or local administration of the NFIP or other federal laws like the Endangered Species Act simply go too far. We'll talk about what the court means by going too far. There are also exemption takings. That has seen quite a lot of play this year in the Supreme Court. This is when it actually allows the landowner to do something as in exchange for the government, for the landowner agreeing to certain conditions or exactions, like dedicating a portion of the property for a public purpose, or make on-site or even off-site improvements to address public needs. A fourth type of taking that's been litigated in the form of judicial taking. We're not going to get into that. The Supreme Court has not concluded that there's such a thing yet. So we're dealing mainly with these three types: physical takings, regulatory takings, and exactions. First, with the physical takings, it means its source in the case of Lowy Teleprompter, Manhattan CATV Corporation. And this is where a New York law has authorized a cable television company to install its components on the property of a landlord. This New York law said that this may not interfere, that the landlord may not interfere with the installation and can't demand payment from any tenants for terminating the cable TV or demanding payment from the company. The landlord may require the company or the tenant to bear the cost of the installation and to indemnify for any damage caused. the fundamental rule here is that a permanent physical occupation authorized by the government is taking without regard to the public interest that it may serve. So any physical occupation, a physical invasion of the land is taking no matter how de minimis. Then we get into the regulatory takings, and this finds its source in the case of Pennsylvania Coal Mayan. In this case, an 1878 deed, Pennsylvania Coal Company had granted the surface rights to a parcel of land, but retained the mining rights, the subsurface rights to the land, and that the property owner Mayan accepted any risk from and waived all claims for damages resulting from the mining below the property. By way of context, we see there actually in a painting from era where subsurface mining had actually caused a building to sink into the land. So in 1821, the Commonwealth of Pennsylvania passed the Kohler Act, which, among other things, prohibited the mining of coal in such a way as to cause this type of subsidence, any structure that was used as human habitation. So Pennsylvania Coal has provided notice to Mayan that it plans to mine for coal. Mayan ended up bringing suit to prevent Pennsylvania Coal from mining under his land pursuant to this act. In dealing with this case, we see the Supreme Court arriving at a certain standard of approaches they're going to take when looking at this type of taking. It essentially deals with the standard of review and the approaches that the court is going to be taking when this type of case comes before them. And a result of the Supreme Court decision in Pennsylvania Coal, court had held that while property may be regulated to a certain extent, if a regulation goes too far, it will be recognized as a taking. In certain situations, the land use regulation can be invalidated as a regulatory taking, and compensation can be awarded to the regulated property owner for the damage caused. This is sometimes referred to as in regulatory takings as inverse condemnation or de facto taking, and both of these terms reference the government's authority to eminent domain. So the broad authority to regulate land use is delegated to local governments, as we discussed in those enabling acts. And the broad authority takes with it the implied authority to choose the means necessary to accomplish the purpose of conserving the value of land and property, encouraging the most appropriate use. So land use regulations that are enacted under the police power are delegated to the state legislature. Challengers carry a heavy burden of proof to prove that the regulations violate a constitutional guarantee. More recently, we see in the case of Lucas versus South Carolina Coastal Council. This is a case, and the graphic sort of says it all there. We see two folks on a beautiful beach. He says, gorgeous beachfront. When you say it's priceless, is it worth millions? And he's saying, no. So this is a second of the so-called prey takings category, where the regulation of property deprives the landowner of economically beneficial use of the property. Here, courts have also applied a heightened degree of scrutiny. Such regulations may be said to constitute a total taking and to implicate the constitutional guarantee that property will basically not be confiscated for public use. Here, the Supreme Court has said that in the extraordinary circumstance where no productive or economically beneficial use of the land is permitted, it's less realistic to, and I'm quoting the court here, it's less realistic to indulge our usual assumption that the legislature is simply adjusting the benefits and burdens of economic life. In such cases, there's a heightened risk that the private property is being pressed into some form of public service under guise of mitigating a serious public harm. Unless the community can show that the use is prohibited by the regulation would not be allowed under nuisance law or so-called background principles of property law, regulation that prohibits all beneficial use. A total wipeout of the economic value of the property will be considered a regulatory taking, and the government owes compensation. What I would hear is that the Lucas decision, even if it was released in 1992, was very limited to the specific facts of this case. And so we have not seen a long line of Lucas-style takings decisions. They exist, but they are very rare. It is linked primarily to the facts of this case. In this case, the State's Beach Management Act had rendered the landowner's two beachfront lots as essentially valueless. Regulations did not have any variance for hardship caused by the prohibition. And so when we hark back to the 1922 case of Pennsylvania Coal, while property may be regulated to a certain extent, if a regulation goes too far, it will be recognized as a taking. So where the government potentially gone too far. But even so, the court recognized in Lucas that, and again I'm quoting, government could hardly go on. To some extent, values incident to property could not be diminished without paying for every change in general law. The court is saying that some impact on property value is to be reasonably expected. And government could hardly go on if it had to get out its checkbook every time those values were impacted by a regulation in the interest of protecting public safety, health, and welfare. It did, however, that regulations that leave the owner of the land without economically beneficial or productive options for its use carry with them a heightened risk that private property is being pressed into service. Unless you were, leaving out all value, where a regulation wipes out all economic value, you are looking at a per se taking. However, when the state does seek to sustain a regulation that does deprive all economic use, the state can resist compensation under some circumstances, but the burden in this case is on the state of South Carolina to identify those background principles of nuisance and property law that prohibit the uses intended, in this case by the petitioner. In the case Penn Central, we see a multi-factor balancing test being articulated by the court. In the Penn Central case, the court recognized that although there existed no set formula for evaluating regulatory taking claims, there are several factors that are going to come in and be important in the analysis. So the court adopted a multi-factor balancing approach to review, in this case, New York City's landmark preservation law. It took the economic impact of the regulation, particularly the extent to which the regulation has interfered with distinct investment-backed expectations, along with the character of the government action. For instance, amounts to a physical invasion instead of merely affecting the property interest through public programs that adjust the benefits and burdens of economic life. In New York City, a landmark preservation law had singled out 31 districts containing 400 landmark buildings for regulation. The buildings basically required to obtain a certificate of appropriateness before allowing alteration of the exterior. In the case of Penn Central, which owns the Grand Central Terminal, they had applied this certificate to build basically a 50-story skyscraper on top of Grand Central Terminal. This permission was denied by the Landmark Commission. Penn Central claimed that the application of law did constitute a taking. And again, here we see the court articulating these so-called Penn Central factors. Moving forward, In the case of Palazzolo, this actually was decided in 2001, found its origins, like many property law cases back in the 1950s, when the petitioner had formed an organization and purchased a parcel of land that bordered on a pond and was a marsh subject to tidal flooding. House had tried to gain approval, Rhode Island Division of Harbors and Rivers, for two development projects that were not approved. The land was designated by the council as protected coastal wetlands. And in this case, the court had disagreed with a portion of the Rhode Island state opinion that held the petitioner's claims not right. It was taking exclusive ownership of the property after the wetlands laws were enacted. Third, the court concludes that it would be illogical and unfair to bar a regulatory takings claim because of the post-enactment transfer of ownership, where the steps necessary to make the claim right were not taken. So the court actually remanding the case for consideration under Lucas. As into additional lines of takings, the Tahoe Sierra Preservation Council case is very important regarding use of moratoria. And this is where a community makes basically call timeout development. And in the flood context, we see after a major flood disaster, communities enacting moratoria in order to take some time for the community to recover from the disaster, for staff to be out there doing substantial damage determinations, and for the community to also take a close look at its development standards, its permitting, its ordinances, its maps, to make sure that they are applying the lessons learned of whatever disaster they were dealing with. In the Tahoe Sierra, this is actually the Tahoe Regional Planning Agency enacted a moratorium. The same could be true of a community or any other regional entity, where in the case of Tahoe Regional Planning Agency, they were working to protect the unique environment and tourist-based economy of the Lake Tahoe region. In saying a moratorium, in this case, it was 32 months. And what we see here is that the Tahoe court concluding that the moratorium, like most other land use regulations, is subject to an inquiry that considers the circumstances of the case, and saying, again, the character of the regulation, the public interest to be achieved, the extent to which the regulation, or in this case the moratorium, interfered with investment-backed expectations, and how severely they were affected by regulation. Another moratorium may be a taking under the circumstances of a particular case, not categorically so. In rule, the court clarified regulatory takings law and essentially corrected its course by saying the so-called substantially advances test, that it belongs in the context of a due process analysis. For a regulation that fails to serve any legitimate government objective, it may be so arbitrary that it runs afoul of the due process clause. And then, through the case of the city of New London, or Kelo versus the city of New London, see the court examining the question of what is a valid public purpose. In the case of Kelo, I think land use lawyers and the nation overall were surprised to find that a valid public purpose was found in a plan for economic rejuvenation, economic development, overall condemned area, even though some individual properties, including Suzette Kelo's, may not be blighted. So in Tahoe Sierra, we see the use of moratoria for floodplain issues. This moratorium, a wise and valid exercises of authority. It makes perfect sense for a community to take some time and catch its breath. I would emphasize the importance of establishing at the outset in a very public way the purpose of moratorium and making sure that you're articulating your public safety, your public health, public welfare reasons for doing moratorium. It can articulate at the front how long that moratorium will last. 12 months and even 24 months is not unheard of. 12 months is probably on very good footing. In the case of Kilo, this so-called valid public purpose doesn't have to be a public park or a public easement. Valid public purpose can even be found in private economic development. I'll spend a little bit of time with you on the case of Doe v. Chatham, even though this is not a U.S. Supreme Court case. It's extremely important and relevant for a couple of reasons. We see here basically the Supreme Court of the state of Massachusetts rejecting a regulatory takings challenge to wetland protection. In this case, Crawford had inherited 1.8 acre lot situated on coastal wetlands in southeastern Cape Cod. For decades, the area had been susceptible to coastal flooding by hurricanes, nor'easters. The lot was also bisected by a tidal creek that was flood prone. In 1985, the town of Chatham designated wetland areas as a coastal conservancy district subject to ban on residential construction to protect public health and safety. In recent years, a breach in the barrier island that protects the town of Chatham from the ocean had led to even more severe storm erosion, causing houses to fall into the sea. This was extremely flood-prone land. In the Supreme Court states, it's undisputed that the parcel falls within a floodplain, that its potential flooding would adversely affect the surrounding areas if it were developed. Reasonable government action mitigating that harm typically does not require compensation. What I emphasize is that the testimony of emergency first responders was found to be very significant to the court. And the lesson here is, as a community is adopting its standards and its regulations to protect people and property and public safety, it's very important to get as much evidence into the record. You do this in a way that's very public. You want to hold your public hearings. You want to contact directly potentially affected property owners and give them a chance to be heard. I also really encourage you to get that testimony of your fire chief, your emergency first responders, your public safety staff, your emergency management staff, and your local floodplain manager into the record when you're adopting this bylaw or this ordinance or this new development standard. If subject to challenge later on, the testimony of those first responders can be brought before the court to explain what it means when a developed area has to be evacuated. What it means when city staff and emergency first responders have to go door to door to effect that evacuation. What it means when they have to be involved in rescue operations, putting themselves in harm's way, right? And also subjecting the community to the extent of that emergency action. And the testimony of risk to the community and to emergency workers is important. So what I'll emphasize with Doe is that the town of Chatham was willing to defend itself. Because a property owner or a developer is raising the specter of taking just because you may have found yourself in court. A community that is willing to stand up and defend itself on public safety grounds is doing its community an important good service. You're very good legal footing. You're enacting regulations to protect public safety. Stay firm if you do find yourself facing those challenges. In this Mansoldo, this is a case before the New Jersey Supreme Court. We see a challenge to the National Flood Insurance Program itself. The community and the state in this case concluding that when actually the government denies all economically beneficial and productive use of land, compensation has to be provided unless, again, these ground principles of law can be brought into the analysis. In this case, the New Jersey Supreme Court demanded for the analysis to go back and follow that Lucas analysis. So where a property owner wanted to construct homes on his property that otherwise had been permitted by the zoning code, there was a challenge because this was eventually going to be development in a floodway. The court has concluded here that you've got to go back and look at and follow Lucas. Interesting twist that's a little bit more recent. We see the U.S. Supreme Court taking the question of whether an artificial avulsion, and I'll explain this. You can see it in graphics. The state of Florida is actually engaging in an engineered effort to nourish the beach. You see the property owner back there in his home saying, "That's a taking, get out your checkbook." This was under the state of Florida's Beach and Shore Preservation Act. And here we see the Florida DEC using its authority to protect its beaches and protect property along those beaches. So the question becomes, did the Florida Supreme Court in its decision actually cause a judicial taking? And we see 4 out of the 9 justices actually saying yes. And this was the question of whether we may at some point end up with this 4th category of types of takings. But as of right now, 5 of the 9 justices have said no. We did end up holding unanimously. The Florida Supreme Court did not take property without just compensation. And it's very interesting that the rationale for arriving at the unanimous part of the decision that there was no taking here is essentially grounded in the Supreme Court's recognition that when it comes to climate change and flood risk, they want the states to retain every tool available to them to combat flood damage and to combat the effects of the changing climate, including, if the state of Florida chooses to do so, beach nourishment. The court did not get into, and I won't on this briefing, value of whether beach nourishment is a good idea or not, or who should pay for beach nourishment. Ultimately, we see the court take flood risk and climate change seriously and wanting the state of Florida to be able to do everything it can to protect itself. As we get to the 3rd type of takings, these are the exaction takings. The line of cases of Nolan-Dolan. In the case of Nolan, the California Coastal Commission had required that owners of beachfront property that want to get a building permit to maintain a pathway on their property to be open to the public. So the question becomes, does this requirement constitute a taking in violation of the 5th and 14th Amendments? The court concluded yes, that it did, and agreed that a legitimate interest can be served by maintaining this continuous strip of publicly accessible beach along the coast. And if California wishes to use its eminent domain power to do this, it needs to provide just compensation to the Nolans and other beachfront property owners for the public use of their land. It needs to be, and quoting the court, it needs to be more than an exercise in cleverness and imagination. So in justifying any regulation or analyzing whether it's constitutional, the court is going to be parsing through these issues and making sure that the building restriction or the requirement for access is a valid regulation of land and not this out-and-out land extortion. The land use regulation is not going to constitute a taking as long as it substantially advances a legitimate state interest. and not deny an owner the economic viable use of their land. Moving in the case of Dolan, we see conditioning the approval of petitioner's building permit on the dedication of a portion of her property for flood control and traffic improvement. And hopefully you can see cursor here. Here is the walkway. Actually going to be the subject of these drainage and flood control standards. And here we see the public walkway. It was actually a private walkway at the time, and the regulation requiring that she actually allow public access. So under the doctrine of unconstitutional conditions, a government not require a person to give up a constitutional right. And here, the right is to receive just compensation when a property is taken for public use in exchange for the discretionary benefit in the form of this permit. There is not a precise sort of mathematical calculation that's required, but the city has to make some sort of individualized determination that the required dedication is related both in nature and in extent to the impact of the proposed development. And here, the court found that the findings the city is relying on not show this reasonable relationship between the floodplain easement and the petitioner's proposed new building. The court also found that the city had to make some effort to quantify its findings in the support of the dedication of the pedestrian bike path, beyond just the statement that it could offset some of the increased traffic that would be generated. So an extension of Nolan's essential nexus test to rough proportionality to the development impact and conditions of development. With, again, this year, we see in a really odd decision out of the Supreme Court in the case of St. John's River Water Management District. I'm doing a really quick time check. Doing well. In this case, Corey Coons, the property owner, had purchased a lot consisting of 14.9 acres, just under 15 acres. And under Florida regulation, but 1.4 of those acres had become a riparian habitat zone, which could not be developed with a permit from the St. John's River Water Management District, which in this case is the respondent. In '94, Coons applied for this permit to develop 3.7 acres of the property. The St. John's River Water Management District agreed to approve the permit if Coons, and again we see these conditions, right? If Coons agreed to one of two conditions, he either had to deed the remainder of his property into a conservation area and perform off-site mitigation on property located 4.5 miles away from his property, or needed to reduce the development to 1 acre and turn the remaining 13.9 acres into a deed-restricted conservation area. In this case, Coons refused to accept either of the conditions, and of course, predictably, the management district denied the permit. Coons brought the lawsuit claiming an improper exaction on his property, and the case went through several appeals before the U.S. Supreme Court granted certiorari and agreed to hear the case. So here we see the court revisiting Nolan Dolan and concluding that courts can choose whether and how a land use permit applicant can be required to do mitigation, may not leverage its legitimate interest in mitigation to pursue if it lacks an essential access or proportionality to those impacts. And in a surprising element here, it doesn't matter whether the government approves the permit with conditions or denies the permit when the applicant refuses to cede to those conditions. So it turns out that the Nolan standard of nexus, it has to be rigid, right? rough proportionality, it has to have the right extent, is going to apply to conditions requiring off-site mitigation. And it also applies the standard of nexus and rough proportionality, the expenditure of funds, including fee in lieu. So, even so, it is permissible to impose the full cost of these development impacts on permit applicants. But the question remains, what effect is the case of Coons, the Johns River Water Management District, going to have on these negotiations and agreements on conditions that arrive at when developers sit down with communities to work through the configuration of their project? It's up to areas of wetlands or floodplains. In my opinion, and my disclaimer, it's just my opinion. In this respect, Coons put floodplain managers on very good footing to continue to do the right thing and taking into account public safety, operate in a manner that's very transparent and upfront, and relating those conditions to public safety and public welfare. Make sure that those conditions are directly related, in the case of flood risk, to reducing flood losses, preventing flood disasters, preventing loss of life. So I don't see Coons as being this terrible curveball, but in the broader planning and land use regulation context, Coons has some consternation. And so it really bears continued monitoring and watching. So ultimately, what's going to constitute a taking? This, again, is a physical occupation of private land, a regulation that goes too far, or a condition that has no rational connection or essential nexus to the valid public purpose you're working to serve, or if the proportionality of that condition is out of proportion to the impact of the development. Again, remember this Lupit-style total deprivation of economic use. These are very rare, but it is still out there. When you interfere with these reasonable investment expectations, and again, compensable taking can occur even when a restriction is temporary. So in the case of moratoria, be prudent, be transparent, articulate your reason for the moratorium right at the outset. Clearly relate your regulation to preventing harm. And again, the testimony of your floodplain managers, your emergency managers, and your emergency first responders. That on the record, just at trial, get it on record at the time that you are adopting a new map, a new standard, a new regulation, or a new permit. First, that Loretto style, avoiding interfering with the landowner's right to exclude others, avoid wiping out all economic use. We're also urging folks to consider transferable development rights or similar residual rights that can serve to actually retain some of this economic value to keep the Lupit land and demonstrate that relationship between the permit condition and the harm to be avoided. The very limited time that I've got left, because I want to save time for questions, I want to get very briefly into some of these federal policy responses to flood disasters. At the outset, we talked about the ways that federal policy, and particularly the federal minimum standards of the NFIP, are not going to be enough to protect you. So higher standards like freeboard, setbacks, building codes, these are going to actually help keep you out of court and to prevail in the event that you do get sued. So we need some progress in federal policy that I think point to state and local authority to, again, and even responsibility to go beyond these federal minimum standards. In the case of Sandy, supplemental appropriations, it was an uphill climb and it became a political battle. $60.4 billion the supplemental appropriations were approved, but it is not automatic. And I think we can expect to see, in the wake of big flood disasters, these supplemental appropriations being harder and harder to get at. We see a Resources Development Act making its way through the Congress right now that has the potential to include a lot of new technical assistance for state and local governments to help all parse through these challenges, identify innovative and affordable and even non-structural approaches to preventing harm, preserving your floodplains and your coastal areas, and ultimately reducing risk. The principles and guidelines, these are federal standards that articulate when the federal government is going to get involved in a major flood control project. Those are also in development and review. Executive orders like 11988, and if you're taking notes, Executive Order 11988 actually precludes the federal government from engaging in activities that are going to increase flood risk if there is an alternative. Federal agencies are going through the process of making sure they're complying with that executive order. We see that the Federal Sandy Rebuilding Task Force and its rebuilding strategy that was released in August, this is a report to the President, producing two important new tools. One is the sea level rise planning tool, particularly for you coastal communities. Definitely take a look at that. The link is provided. It actually gives you a good idea of what you can expect to see in sea level rise. We also see, for the first time in our nation's history, what we're calling Federal Freeboard. This is the federal government acknowledging best available data, an advisory-based flood elevation after a disaster, or even FEMA's current flood insurance rate map being good enough. So if you're spending those dollars from the Sandy supplemental appropriation, you're going to use best available data plus 1 foot. Now bear in mind, this is being applied throughout the Sandy affected region. So we know that many states and certainly many communities have gone well beyond 1 foot. My point here is, for the first time, the federal government is acknowledging that best available data is not good enough when you're spending federal taxpayer dollars. These two big policy moves, the sea level rise planning tool and this free board, in view, put state regulators on even better legal footing in adopting 3 free boards, 4 feet or even more, in the interest of public safety, adopting setbacks, adopting standards that treat your entire floodplain like floodway, so having a no-rise, a zero-rise floodplain, you're on very good footing, adopting strong and robust building codes, and anything in hazard mitigation that reduces costs and takes into account the effects of climate change and recognizes that so-called best available data may be good enough for your community. So we see in federal policy good legal footing for the responsibility of state and local government to ensure that the actions of any community or property owner are not going to adversely impact others, and incorporating a more multi-objective approach so that you're looking not just at flood risk, but you're thinking about things like water supply, water quality, stormwater. Ultimate benefits are pretty obvious. You're going to reduce your flood losses. You're going to reduce costs to your community. You're also going to be reducing your potential legal liabilities. You're going to be reducing your chances of being called into court. But if you do get sued, you are increasing the chances that you'll win. You may be helping to reduce the flood insurance premiums that property owners in your community may end up paying. Joining the community rating system is not only encouraged, but it will look very good to a court that your community is proactive enough to get out in front of these issues and recognize your authority to exceed those federal minimum standards. Includes multiple objectives and protect those natural floodplain resources and values. I realize you are more likely to be successfully sued for permanent risky development than preventing it. So if you permit development that causes harm, you can get yourself and your community in trouble. But when you are preventing that sort of risky development, you are on very good legal footing. You are your community's first and last line of defense against the next disaster. Adopt those higher standards, tie them directly to public safety, and take them to your own community. When development is proposed, identify those impacts and mitigate those impacts. If we continue to just rely on these federal minimum standards and allow at-risk development, there are consequences, and ultimately it's going to be local governments that get hauled into court, not feds. I'm going to wrap up there and reserve the rest of the time for questions that you all may have.
Thanks, Sam. I'd like to open up the floor now. Let me try and unmute everybody here so they can. All right. Feel free to speak up if you've got questions. Related to her presentation.
Yeah, I would just like to thank you for this information because it helps not only in floodplain management when we're doing agency acquisitions. It's information helpful to give to the agencies when they're building things in wetlands and plains that they're aware of. So thank you for this information.
Sure. Again, I may be one of the few lawyers trying to help keep people out of court, but also just help promote good approaches and good standards. And like you say, it applies not only in the floodplain, but also wetlands and other contexts.
Feel free to also submit questions via chat, but by all means, feel free to speak up as well. Questions or comments for Sam?
Well, I've done my job very well, or I've overwhelmed folks with great information.
I've heard presentations like this before, Sam, and by far yours was packed with the most detail that I've seen. So thank you for that. If there are questions for today's presentation, I'd like to thank Samantha for volunteering her time. If the participants joined after our roll call, please chat with your name, organization, and whether or not you're a CFM so we can record your name in the list that we submit to ASFPM for CECs for today's presentation. You should see my slide now with our upcoming topics. We've got a season title here for our next Lesson Learn in December. Terry Turner is coordinating. And then next spring in February, we'll be looking at, I guess that's winter, we'll be looking at some mitigation related topics, so stay tuned for those. And if, we just the list of topics from our NAI Principal Community Surveys that we submitted to Georgia floodplain officials. However, we're open to new ideas, topics, and presenters. So if you've got an idea or a presentation that you'd like to give or a topic that you'd like to hear about, feel free to send me an email with your contact information or your ideas, and we'll be glad to incorporate those. And thanks for your time today and tuning in, and we'll wrap up and hopefully hear from you all or talk to you all on December 4th.
Sean, and thank you everyone for joining.
Thanks, Sam.
Thank you.
Bye.